Hello guys, my name is GAURI BANDRE. I'm an intern at LEXIS and Company, and my topic for today's discussion is will. So we'll talk about what is will, how one should make a will, what are things you need to remember while making a will, different sort of doubts and questions that one can get while making a will. I am going to try and clear each and every possible question. So let us begin by understanding what is will. A will is a legal declaration made with respect to your assets or property. This document takes effect after your death, as the person making the will is known as testator and the one who helps in executing the will after your death is known as executor. So what is the significance of will? Why it is necessary and more preferred that one should make a will? One, to resolve any dispute which will arise regarding your assets or property after your death. Second, for you to pass the property and assets to the person of your choice. If you want to pass an X and Y person, then it is more preferred that you should write a will beforehand. Now, if in case the person does not write a will, then the division of property will be on the basis of your own customary law. In case of Hindus, it will be according to Hindu Succession Act. In case of Muslim, it will be according to the Muslim personal law. And again, it will vary from religion to religion. Now, when can one make a will? One can make a will at any point of time in their life. But should have attained the majority of age, that is plus 18 years. In case if the person is of unsound mind or is dealing with some disability, then in that case the person should make a will when he or she is at a reasonable state of mind. Is witness necessary while signing a will? Yes, witnesses are necessary while signing a will. At least there should be two witnesses, and the witnesses should also sign a will along with the testator. Who is executor and who can be appointed as an executor? Executor is a person who will succeed you and who will execute your will after your death. The things which you should remember while making an executor is: one, the person should be of sound mind. Second, the person should have attended the majority of age. Third, the person should be trustworthy and responsible. Next is the person. It is more preferred that you make a younger person as your executor, as he or she should succeed your death. Now, the executor should also be known to the beneficiaries. Now, the very common question which arises is, can you change or alter your will which you have already signed? Then in that case, yes, you can change or alter your will. If you are planning to make a substantive change, then it is preferred that you execute a codicil. Now, what is codicil? A written statement which supplements or modifies an existing will is executed in the same manner, in that case of an original will. Now, what all changes you can make? You can either change the beneficiaries, you can delete or modify or insert any new language, etc. But after making certain changes, it is mandatory for the witnesses and the testator to sign the will. Now, you cannot make any changes in case of an executed will. The will which is already executed, in that case, you cannot change the will because it is already executed, obviously. Now, can you undo or cancel the will? Then yes, you can undo or remake any will, or you can even tear the will apart, or you can burn the will. If you want, you can ask any person in front of the testator to do so. So it is at your choice. The next question is, can you give away your will? Yes, you can give away your will, but the ownership should belong to you. Now, in case if the will is passed on to you and you want to give away that will, then in that case you cannot do so, because there is only your life interest lying with that will. You don't have any sort of ownership over that property or the asset that is passed on to you by some other person. In case of Hindu joint family, you can only give away your interest of the property. If you have any joint beneficiaries along with you, then the consent of the joint beneficiaries is mandatory. If in case you have any movable or immovable property at your own name, then you can pass or you can give away your own property. Now, when is an administrator appointed? Now, if you haven't appointed any executor, then in that case, the court has an authority and the power to appoint an executor. If he or she refuses to execute your will, then the court shall appoint an administrator. Is it necessary for you to register your will? If in case you want to register your will, then how can you register your will? First of all, it is not mandatory for you to register your will. In case you want to register your will, then in that case you can go to an authorized agent or you can personally do so. You have to deposit the will with a sealed cover bearing your name or of your agent, if any, with a statement of the nature of the document to the sub registrar of the local division. Once the registrar receives the cover and is satisfied, the she or he will keep the sealed cover in his custody. Now, if you wish to revoke or change anything to an existing will, then you may apply either personally or through a duly authorized agent to registrar. And if the registrar is satisfied that either of you or your agent have applied, she will return it. On your death, a person can make an application to the registrar to allow to get the will or to see the contents of the will. What are the things that you should make a point of while drafting a will? First of all, your intention should be express your wishes regarding your assets or your property, etc., in simple and very clear language, which does not leave much room for confusion or interpretation. Second, the object or subject of your will should be described accurately to avoid any further confusion. Uh, Third, the will should begin with your name and should ideally mention that it is your last will. It should also mention the date and place of the execution of the will. You should mention that you are making the will voluntarily or of your own free will without being forced to do so if in any manner, and that you are in a sound state of mind. Next is that the will should begin with your name and should ideally mention that it is your last will. It should also mention the date and place of the execution of the will. So these were a few of the points that one must remember while making a will. I hope that this has cleared some of your confusion, and if you like this video, do subscribe to this channel. Thank you.